Lesson: Avoiding conflicts of interest. Avoiding conflicts of interest is a critical component of ethical practice in contract law. Contract law specialists must navigate complex situations where personal interests could potentially interfere with professional duties, leading to compromised decisions and actions. Understanding and effectively managing these conflicts is paramount to maintaining professional integrity and upholding the trust placed in legal practitioners by clients, colleagues, and the legal system. This lesson delves into practical tools and strategies that contract law specialists can implement to identify, mitigate, and resolve conflicts of interest, ensuring adherence to ethical standards. A conflict of interest arises when a person's personal interests could potentially interfere with their professional responsibilities. In contract law, such conflicts can manifest in various forms: financial interests, relationships with parties involved in the contract, or positions held outside the legal practice. To address these challenges, contract law specialists should employ a systematic approach to identify potential conflicts early in the contract negotiation or drafting process. A practical tool for this purpose is the Conflict of Interest Checklist, which prompts professionals to consider critical questions about their relationships, financial interests, and external commitments that might influence their impartiality. For instance, a lawyer involved in drafting a contract for a company where they hold shares should disclose this financial interest to avoid any perception of bias. Transparency is a fundamental principle in managing conflicts of interest. Professionals should communicate openly with clients and relevant stakeholders about any potential conflicts and the steps being taken to mitigate them. This transparency not only protects the professional but also reinforces trust with clients and partners. Once a potential conflict is identified, the next step is to assess its significance and determine an appropriate course of action. The 4Rs framework, recognize, reveal, resolve, and review, serves as a practical guide for effectively handling conflicts of interest. Recognize involves identifying the conflict and understanding its nature and implications. Reveal entails informing all relevant parties about the conflict, maintaining transparency and openness. Resolve focuses on implementing measures to mitigate or eliminate the conflict, such as recusal from decision-making or seeking an independent review. Finally, review involves regularly reassessing the situation to ensure the conflict remains managed effectively. Consider a case study involving a contract lawyer who is asked to represent two clients with opposing interests in a negotiation. Applying the 4Rs framework, the lawyer first recognizes the conflict and then reveals it to both clients, explaining the potential impact on their representation. To resolve the conflict, the lawyer might choose to represent only one client or suggest alternative legal representation for the other party. By reviewing the situation periodically, the lawyer ensures that the conflict does not reemerge as the negotiation progresses. Statistics from the American Bar Association indicate that conflicts of interest are among the most common ethical complaints against lawyers, highlighting the necessity for robust conflict management practices. Utilizing conflict management frameworks such as the 4Rs can significantly reduce the risk of ethical violations and enhance professional credibility. Training and education play a crucial role in equipping contract law specialists with the necessary skills to identify and manage conflicts of interest. Regular workshops and seminars can provide professionals with updated knowledge on ethical guidelines and practical strategies for conflict resolution. Additionally, mentorship programs can offer less experienced lawyers the opportunity to learn from seasoned professionals who have successfully navigated complex conflicts of interest. Technology also offers valuable tools for managing conflicts in contract law. Specialized software can help track client relationships, financial interests, and other potential sources of conflict. These tools can automatically flag potential conflicts, prompting further investigation and action. By integrating technology into their practice, legal professionals can enhance their ability to manage conflicts efficiently and effectively. Implementing organizational policies that promote ethical behavior and conflict management is essential for law firms and legal departments. These policies should include clear guidelines on identifying and handling conflicts of interest, procedures for reporting and addressing concerns, and regular training sessions to reinforce ethical standards. Establishing a culture of ethics within an organization encourages all members to prioritize integrity and transparency in their professional interactions. A noteworthy example is a major law firm that implemented a firm-wide policy requiring all lawyers to undergo annual ethics training focused on conflict of interest management. This initiative led to a noticeable decrease in conflict-related complaints and reinforced the firm's reputation for ethical practice. By fostering a culture of continuous learning and ethical awareness, organizations can empower their members to handle conflicts of interest with confidence and competence. In conclusion, avoiding conflicts of interest is a fundamental ethical consideration in contract law. By employing practical tools and frameworks, such as the Conflict of Interest Checklist and the 4 Rs framework, contract law specialists can effectively identify, assess, and resolve conflicts, ensuring ethical practice and maintaining trust with clients and stakeholders. Through education, technology, and organizational policies, professionals can enhance their proficiency in managing conflicts of interest, contributing to the overall integrity and credibility of the legal profession. Engaging in these practices not only safeguards the interests of clients, but also upholds the ethical standards that underpin the practice of contract law.